Judgment on the appeal of the Queen on the application of Eastenders and the Queen on the application of First Stop Wholesale.
Lord Reid will summarise the decision of the court.
These appeals concern the question whether customs officers have the power to detain goods where they have reasonable grounds for suspecting that the goods may be liable to forfeiture because, for example, excise duty has not been paid, and they require to make further inquiries. The facts of each appeal are similar. Customs officers carried out an examination of alcoholic goods which they found in the appellant's premises. They had reasonable grounds for suspecting that duty had not been paid, in which event the goods would be liable to forfeiture. In order to find out whether that was in fact the position, they needed to investigate the provenance of the goods. In the meantime, they detained the goods so as to secure them until the investigation had been completed. After the necessary inquiries had been made, some of the goods were seized and forfeited, and the remainder were returned. In the Eastenders case, the owners of the goods challenged the lawfulness of the detention of the goods which were not forfeited. In the First Stop case, the owners challenged the lawfulness of the detention of any of the goods on the basis of a suspicion that they were liable to be forfeited. In each case, the Commissioners of Customs and Excise relied on Section 139 of the Customs and Excise Management Act 1979, which authorises the detention of goods which are liable to forfeiture. The Court of Appeal held in the Eastenders case that those words meant actually liable to forfeiture, not merely potentially liable to forfeiture. On that basis, the officers were held to have acted unlawfully. The Commissioners appeal against that decision. In the First Stop case, the Court of Appeal held that the detention of the goods was lawful provided they were in fact liable to forfeiture, even if the reason given for their detention was merely a suspicion that that might be the case. First Stop appeal against that decision. A consequential issue relating to costs is raised in a second appeal by First Stop. This court unanimously allows the Commissioner's appeal in the Eastenders case and dismisses the principal appeal in the First Stop case for reasons set out in a judgment by Lord Sumption and myself, with which Lord Newburger, Lord Mance and Lord Carnwath agree. The court agrees with the Court of Appeal that Section 139 applies only where goods are actually liable to forfeiture. That interpretation is supported by other provisions of the 1979 Act, which clearly use the phrase liable to forfeiture in that sense, while other provisions expressly allow customs officers to act on the basis of suspicion. The court also notes, however, that that would have troubling implications if customs officers had no other power to detain goods. Detention on the basis of suspicion would be unlawful in all cases where the suspicion turned out to be unfounded, and this would be problematic in terms of compliance with EU law and the Human Rights Act. Furthermore, the practical operation of the Customs and Excise Acts requires officers to be able to secure goods, where there are grounds for suspicion that they are liable to forfeiture, until the necessary inquiries have been completed. The Court also notes that there was no equivalent of Section 139 until that power was introduced in 1952. Long before that, however, the courts had interpreted customs officers' statutory powers to examine goods as including by necessary implication an authority to detain the goods for such time as was reasonably necessary in order for them to make any further inquiries which were necessary before they could make their determination. That power was not conditional on the goods being actually liable to forfeiture. Reasonable grounds for suspicion were enough. The Court concludes that when Parliament enacted the 1952 Act and introduced the power which is now contained in Section 139, it did not abolish the pre-existing power of detention. The customs officers were therefore entitled to detain the goods in the present cases. In the light of that conclusion, the Commissioners succeed on the principal issue raised in both appeals. As regards First Stop's appeal in relation to costs, It follows from our decision on the principal issue that the courts below proceeded on a mistaken understanding of the law which was relevant to costs in this case, and that the issue will have to be reconsidered in the light of our decision.
Court is now adjourned.